Welcome everyone to this online event, the farewell remarks by outgoing Appellate Body member Dr. Zhao. My name is Joost Pauwelyn and it's my honor to be moderating the event. I'm the co-director of the Graduate Institute's Center for Trade and Economic Integration, and also on behalf of the Geneva Trade Platform, welcome everyone. It's a historic day. We are the 30th of November 2020. This is the last day of the last member on the WTO Appellate Body, and we are very proud to have the occasion today to hear the farewell remarks by Dr. Zhao. She was appointed to the Appellate Body member on the 1st of December 2016, which is a 4-year term, so today actually is her last day in office. And normally she would be giving her farewell speech at the Dispute Settlement Body or in front of all the WTO members, with a new Appellate Body member being sworn in. But as you know, or most of you know, the DSB is not meeting this month because of COVID, and also there is no new Appellate Body member to be sworn in. So like the previous outgoing members, the speech, the farewell remarks need to take place off-site. Dr. Zhao comes to us, of course, as the outgoing Appellate Body member, but a little bit of background to her career, which is very impressive. She has law degrees from Beijing University, both bachelor, master's, and PhD. Many people in Geneva also know her from her days as a legal counselor here at the Chinese mission to the WTO. And she's also worked for many years for the Chinese Ministry of Commerce as a trade negotiator. Now, I looked briefly at the past 4 years, and I noticed that Madame Zhao served on 9 appeals, 3 as presiding member. And for the WTO lawyers listening, you may recall some of the cases she worked on, and just a few of the very prominent ones: US Tuna 2152, Brazil taxation, Indonesia steel safeguards, Ukrainian ammonium nitride, or some of the cases she worked on. I'll be stepping aside, but I'll be moderating from the fringes. Madame Zhao will speak to us for 45 minutes, which will be really interesting, giving her insights. And then she has agreed to share or stay with us for 10-15 more minutes to engage in a Q&A. Now, I'll be taking your questions on the chat, so please put them on the chat. I will then read them out to our speaker at the end of her presentation. Dr. Zhao, the floor is yours.
Excellencies, ambassadors, head of delegations, colleagues and friends, Professor Pauwelyn, friends of Graduate Institute, those who are online or present, ladies and gentlemen, good afternoon. Today marks the end of my term as the Appellate Body member. From tomorrow on, the Appellate Body will be an entity that exists only in the Treaty of DSU. As required by a tradition, as well as the duty of a last sitting member, I shall present the farewell remarks today and share with you my reflections on the dispute settlement of the WTO. It may take a bit longer time than usual, for which I beg your pardon. I have to confess that I didn't join the Appellate Body in its heyday. The selection process of new Appellate Body members was suspended since May 2017, merely half a year after my term of office had started. Witnessing the attrition of Appellate Body members until it was unable to work was painful. On one hand, there were mounting pressures on the Appellate Body from the outside. On the other, the caseload never stopped rising, even during 2020. It has provided a unique opportunity for me to reflect on the fundamental issues underlying what had happened. The divide of members' positions on the AB matters for the past 3.5 years was deeply and unprecedented in the history of multilateral trading system. Being fully aware of it and constantly reminded of my duty as an appellate body member to settle the dispute for the WTO members, independently and impartially, I spent enormous time scrutinizing all the criticism and comments that I could collect and all relevant documents on negotiating history before I drafted these farewell words for today. I know the WTO members expect a neutral and objective view on these thorny issues from an AB member. I hope that the views presented will function as a stepping stone that will help bridge the divide and provide a rational basis in enhancing the understanding and help members to find solutions for going forward. The world needs a heel, and the trade world should be together. This is the biggest ever challenge in my entire professional life. However, it was a task that I can't shine away, as I believe it is the duty of me, as the last sitting adjudicators, to the 164 WTO members. I will present it independently and impartially as the duty on AB member so defines. Firstly, let me be frank. Though cases still being brought to panel stage, which manifest WTO members' continued confidence in dispute settlement system for the time being, the docket of AB continued to grow even after December 10, 2019, when AB announced to suspend all cases at hand and was unable to hear any new appeals. It was really worrisome. While the WTO members constantly resolved to appeal to the void AB, up to now, there are 14 pending cases before AD altogether. 4 of them were appealed after December 10, 2019. If the situation continues, it will signify that the WTO dispute settlement system has been brought back to the GATT era, when panel reports could be easily blocked by any defendant. It makes the WTO dispute settlement effectively non-binding. This has been a dramatic derogation and regression from the WTO dispute settlement system since the Uruguay round. To avoid complete paralysis, actions must be taken to fix the current situation. The stalemate in one key pillar, i.e. the dispute settlement, plus a lack of progress in another pillar, i.e. the negotiation, are no good signs for the future of the multilateral trading system. The WTO's existential crisis is looming large. This should be highly alerted and clearly sensed by all members. Save the dispute settlement system, save the WTO. There's no time to waste. This is the first message I will take this chance to convey to WTO members and the trade world. In the following remark, I will address 4 issues: the reflections of the debate on AB, the contributions of AB to dispute settlement and international rule of law. Third, underlying reasons and lessons learned. Lastly, the way forward, suggestions for the future. Firstly, reflection over the debate on AB. A disclaimer and an introduction. Disclaimer: the view expressed is purely of myself and not representing AB or any agency. The intention is to facilitate WTO members to better understand the debate before they make their decisions. I will provide a framework analysis rather than to give an answer. Introduction: the conflict of ideas. After an overall review of all debates on AB among WTO members, which the earlier criticisms could be traced back as early as to 2002 and 2003, I feel somehow the whole debate reflects a strife of 2 contrasting views and different preferred styles of adjudication of WTO dispute settlement among members. It also implies very different expectations of WTO members from the Uruguay round negotiating outcome. To some extent, the debate is actually a carryover of differences of negotiation that's smartly embedded into the treaty, with constructive ambiguities 25 years ago. Ineptly and sadly, the beliefs in different ideal international adjudication in members' mind clashes with the WTO dispute settlement in the treaty. I'd like to review at least two sets of conceptual issues with respect to international adjudication before looking at those debates in real life. First, the conflict of ideas. An ad hoc approach vis-à-vis consistency approach. International adjudication has come a long way from war to peace, from bilateral settlement to third-party adjudication, from diplomatic conciliation to legal settlement, from ad hoc adjudication to institutional adjudication, from bilateral to plurilateral and multilateral adjudication, from one stage to two stages of adjudication. It moves in a seemingly spiral trajectory in the evolution of adjudicatory form, aiming at achieving justice among stakeholders in relevant international fields. Some believe, unlike domestic adjudication process, international adjudication should follow an ad hoc approach and should desirably be conducted on a case-by-case basis as far as participating members so agree. Investor-state dispute settlement at ICSID could be such an example. Some insist that international adjudication should maintain consistency of its decisions. Both ICJ and ECJ, though not recognizing any binding effect of their own decisions, do take previous decisions into great account. The ad hoc approach and the consistent approach treat previous decisions, precedents, and jurisprudence quite differently in international adjudication. Obviously, critiques on AB's practice prefer the idea of ad hoc approach to the consistent approach. While the majority members of DSB indicate their preferences of consistent approach by emphasizing the importance of maintaining consistency and predictability in the interpretation of rights and obligations and the cover agreement. In my view, the different preferences and emphasis of two approaches represent hardcore of divisiveness of members' view on AB's practice of its adjudication. Second, the different styles of international adjudication. Judicial activism vis-à-vis judicial restraint. Judicial activism and judicial restraint definitely belong to those most difficult legal vocabularies to be defined in terms of their nature and scope. Here they are used just for the convenience to illustrate the two different types of adjudication style. Judicial activism hereafter refers to adjudicating style whereby adjudicators are active in making decisions or providing interpretations, while judicial restraint refers to an adjudicating style whereby adjudicators are restrained and cautioned in making sweeping decisions or providing comprehensive treaty interpretation. There is no universal views on adjudication style of AB by the WTO members and academics in international trade area. The current criticism on AB's practice are seemingly referring to a sort of active adjudication style of AB in making decisions and providing treaty interpretations, while a restrained adjudication style of AB is much preferred or expected by the opponents. After a brief overview of the two conceptual legal issues pertaining to adjudication as introduction, let's look at essential allegations against AB on which members hold divergent views. To me, the benchmark of measurement of whether AB did or did not operate as it was designed should be the treaty of WTO, not expectation or belief in the minds of the people who so claim. So let's take a preview of what is in the treaty and assess those challenges by comparing the treaty itself with its application in the reality. First, did AB overreach? The issue of overreaching. If overreach is defined and refers to the situation where adjudicators make decisions outside the scope of issues appealed or make decisions on issues not necessary for settling a dispute, I would agree with it and actually did so in my terms as AB members. Yet some criticism on AB seemed to point to AB's creation of jurisprudence, establishing binding precedent, making rules rather than settling individual dispute. These claims are mostly premised on third sentence of Article 3.2. Now, I have only one question to what is the function of the first sentence of Article 3.2, which provides that dispute settlement is a central element in providing security and predictability to the multilateral trading system. Thus, whether providing security and predictability to the multilateral trading system is the ultimate objective or purpose of dispute settlement, or whether it is an integral part of that objective purposes of dispute settlement, becomes a vital issue. If the first sentences of 3.2 should be given a weight interpreting the purpose objective of the DSU, the panel and appellate body are both required to perform their duties to achieve security and predictability to the multilateral trading system. In that context, panel and appellate body are just working towards achieving the purpose and objective of the DSU by maintaining like decision in like case and following jurisprudence in interpreting of the same provision and the cover agreement. If so, panel's appellate body did or did not overreach, but performed their duty under the mandate of the treaty. Therefore, a careful reading of Article 3.2 and other provisions of Article 3 of the DSU, objectively and holistically, it could be well noted that the WTO dispute settlement function in two perspectives. One, to settle the dispute specifically, that is first and foremost. The other is to provide security and predictability to multilateral trading system generally. These other two perspectives should work effectively complementary with each other. Second, did AB interpret rules or make rules? This critique seems referring to the alleged overreaching of AB individual cases or on specific situations. The issue make it clear that WTO dispute settlement is to preserve rights and obligations of member rather than create rights and obligation. It is obvious dispute settlement is not set up for making rules, yet panel appellate body are instructed to clarify existing provision in accordance with customary rules of interpretation of public international law. Thus, it is obvious that treaty interpretation is a key method to clarify existing provisions in order to settle the dispute. In another word, WTO dispute settlement is centered on treaty interpretation. Then the issue arises when treaty itself is drafted with constructive ambiguities, and that ambiguity has been raised by the WTO member, and the dispute settlement proceeding could clarify existing provision through treaty interpretation for the sake of resolving that dispute, constitute the so-called rulemaking or gap filling. To me, that is the real hard issue and a very close call. It leaves the adjudicating body two options. It either becomes unable to deliver its decision or runs the risk of stepping the red line. If taking an extreme strict view to interpret adding or diminishing rights or obligations. Let's try to look at it more closely. Firstly, on specific dispute settlement. For any matter that is raised properly before the adjudicating body, it is, by definition, within the autonomy or discretion of the adjudicating body to render a decision within its scope of judicatory review as required by the DSU. It is, at least, not overreaching. Secondly, if the adjudicating body conducted treaty interpretation in accordance with customary rule of interpretation of public international law as mandated by DSU, it shall not be regarded as rulemaking per se. Thirdly, if the ambiguity issue is properly raised before the adjudicating body, it means that member is ready to subject itself to the jurisdiction and prepared to accept the adjudicating outcome. A post hoc result-oriented criticism would spark concerns whether these critiques are in line with the good faith implementation principle in treaty implementation under the Vienna Convention on Treaty of Law. Fourthly, should adjudicating body decline to render decision pertaining to interpreting any provision with ambiguity, is in conflict with the requirement of addressing each of the issue appealed before it under Article 17.12 of DSU. Following the above discussion, if a term or concept that is not perceived to be drafted with ambiguity in the negotiation, which implies an ordinary meaning to be given of it, should there arise a need to define it for the dispute settlement purpose. If so, could the adjudicating body's provision of a definition to such a term constitute an adding or diminishing rights obligations under the Article 3.2 of the SU? Is adjudicating body interpreting rule or making the rule by providing such a definition of ordinary meaning for the purpose of settling the dispute before it? I just posed this question to all of you. These could be crucial issues that the WTO member wish to determine so that it could provide clear guidance to its adjudicating body. The other issue that could affect whether adjudication interpretation by adjudicating body would constitute rulemaking is what effect will be given to that interpretation by the adjudicating body. Does the specific interpretation bear any binding or persuasive effect? Third, an issue of adjudication style. To me, the major criticism or concerns on AB, such as overreaching rulemaking advisory opinions or obiter dicta, can actually be ascribed to an issue of adjudication style. As indicated in the beginning, international adjudication could be characterized into two styles, i.e. the adjudicatory activism and adjudicatory restraint, respectively. To my knowledge, there's a general inclination of the WTO members to prefer slim reports with sound reasoning to lengthy and complicated reports. This has become a gross concern by members for quite a while. I believe both panel and AB have put an effort to address this concern of members. Perhaps they have not yet met the varied expectations of WTO members. I think this is an issue that AB should seriously consider to further improve. Though the scope and size of appeal sometimes play a paramount role in the size of the report rendered, to me, rigidity in format in producing reports sometimes could make reports unnecessarily repetitive, and there's a room to improve the drafting. With respect to reasoning and interpretation offered in the report, my view is the legitimacy of the report may be undermined if legal reasoning may be sacrificed in the report for the sake of sameness of it. An adjudicating body achieves its reputation by producing credible and rational analysis, which I believe is much appreciated by member and WTO legal community alike. After cursory review of the statement of WTO members at the DSB and academic works and comments published by international trade circles, my impression is there are wide-ranging and even contrasting views on the outcome and the style of AB reports. Some commend it, mostly members welcome it, and almost every member pledged to implement it contingent only on the need of RPT, the reasonable period of time for implementation. Some scholars believed AB is doing less than it should in interpretation, noticing that AB avoids sweeping statement and taking cautious attitude that might be regretted. Of course, some complained about the opposite. To me, the concerns members expressed on AB are mostly caused by different understanding of AB's nature and function. However, it also caused largely by different ideas and styles of international adjudication. In my view, every adjudicator has its own trial and style of adjudication. As long as the adjudication is within the mandate and compatible with the applicable rules, each adjudicator may exercise his or her adjudicatory autonomy and discretion. At the same time, I also recognize there exists room to reconsider and to improve AB's adjudication style. Perhaps more cautioned and restrained attitude in adjudication would be much safer and desirable, in particular because the participants are mostly sovereign states and most of the issues involved are highly sensitive. Personally, I always hold a strict line in sticking to the treaty and interpret each treaty objectively, faithfully and in good faith as treaty provides. Fourthly, the issue of precedent. Precedent is another highly controversial yet complex issue. It holds a central place in the whole debate. To me, the rule of precedent is a typical phenomenon of how deeply a common law tradition could impact the state practice in international adjudication and adjudication practice of international adjudicating body. From the eyes of lawyers of continental law countries, it's a bit bizarre why there's a need to rely on past decisions to litigate the case while the law itself is self-evident. Why the judges, whose job is clearly defined to apply the law to facts and not allowed to make law, have the need to look at and rely upon previous cases to make their judgment. Yet surprisingly, the rule of precedent, a heritage from Anglo-Saxon law, not only influenced the major continental law countries' judicial practices, but also penetrated widely into many fields of international adjudication. It will cost another lecture to make this matter thorough. For now, let us focus on the impact on WTO litigation. Interestingly, it is most the common law countries who carry on this heritage around the world now criticize the appellate body for its adjudication practices based on case law. Precedent is a concept, rule practice rooted in history of Anglo-Saxon common law system where judges are bound to the court's past decisions, which is also known as a principle of state decisis. Whereas in a number of civil law countries, courts rely on doctrine of jurisprudence constans, where judges find sound reasoning of previous decisions are highly persuasive but not binding or controlling on issues of law in later adjudication. Therefore, though the legal theories or concepts of the two major legal families differ significantly with each other, their practices actually have achieved similar effects in maintaining the consistency of decisions by judiciary body. Though international law doesn't contain rule of precedent per se in many treaties, at least to my knowledge, it has become a prevalent practice by major international adjudicating bodies. Even in the context of the ISDS, which is an area where fragmentation and lack of coherence of ISDS jurisprudence had been widely complained of, the arbitral tribunal often referred to award rendered by previous tribunals on issues such as definition of investment, etc. My colleague, Mr. Ricardo Ramirez, claimed in his farewell speech that I've never seen a member who has not argued this case based on previous case law. Indeed, citing and relying on past decisions has become a normal practice at dispute settlement at both panel appellate body and the WTO. From the perspective of those who criticize AB's practice, AB at least maintained a certain form of de facto precedent, which allegedly exceeds its mandate of adjudicating of each dispute individually on a case-by-case basis. From the perspective of a larger number of WTO members, though recognizing precedent is not created through WTO dispute settlement proceeding, members of WTO emphasize consistency and predictability in the interpretation of rights obligations under the cover agreement is of significant value to members. From the perspective of daily practice of dispute settlement at the WTO, it is no wonder that the driving force to run the cases is the WTO member, who are represented by their super competent international lawyers. Judicators, panel appellate body are merely recipient of legal complaints represented and responded. Therefore, if there's an ecosystem of the WTO litigation, panel appellate body are only part of it. If members and their lawyers continue to present their submission or oral statements with dozens of case law as arguments or reasoning, it is very difficult for panel appellate body to refrain from responding to it or give a value to past decisions. From the perspective of principle of equality before treaty and equal justice under treaty, the issue becomes all members 164 have an equal opportunity to access to and enjoy equal adjudication under WTO dispute settlement in terms of both their procedure and substantial rights under the CAR agreement. I do not see if any member would like to accept a different adjudication outcome on the same issue in similar situations. If dispute settlement could not render fair outcomes, what is the use of going through it? This raises the ultimate purpose and meaning of international adjudication. How could the dispute settlement be sustainable if constantly renders frivolous or conflicting outcome? This is the fundamental issue that WTO members should reflect before make their decision. This will also determine the future direction of the dispute settlement at the WTO. To me, precedent is just a legal methodology to achieve the rule of law. This is actually an issue on how to achieve proper balance between certainty and flexibility of a adjudicating system. A typical conundrum entertained by any legal system of rule of law. In another word, it is an issue whether the adjudicating system could accommodate the changes of time or correct its own mistake, if any. Even the legal regimes where the rule of precedent play a dominant role, there exist situations where adjudicators could distinguish, escape, or even overrule previous case law, as far as they can provide sound reasons. Therefore, what I suggest for members to consider bringing into the WTO dispute settlement the doctrine of jurisprudence constant as a way to resolve this conundrum, a principle of practice from the continental law system. It will help resolve the sensitive issues of how to treat previous decisions by adjudicators within the WTO dispute settlement, as well as taking account the need to maintain the consistency and predictability of the system by giving no binding effect of any previous report, while recognizing its persuasive effect to later cases, wherever appropriate. Hope the switching from common law tradition to civil law methodology could be a pragmatic, balanced middle way to resolve this conundrum of dispute settlement practice at the WTO. Fifthly, why a second stage of adjudication? A second stage of adjudication is not only a quid pro quo for parties' concession to give up their political right to block adoption of panel report, but also a chance to correct mistakes. To WTO members, it also means a second chance to be heard by the adjudicators on the legal matters, and thus a fairer outcome might be obtained. It matters with the procedure right of WTO members to have fair access to adjudication where they see a legal error in panel report. If the multilateral treaty system established two stages of adjudication within the treaty, it is a fundamental right of members to keep it and ensure that right is readily accessible. Could the second stage involve and accommodate the changes of time and correct its own mistake, if any? First and foremost, it is through the legislative action, i.e. the Ministerial Conference or General Council, to make and amend treaty, issue authoritative interpretation to update the rule book so that adjudication body could follow. Second, adjudicating body itself, i.e. the appellate body, could accommodate the change of circumstances and update its jurisprudence based on sound reasons, whether it is appropriate. My understanding is that AB did evolve in jurisprudence as time went by, just maybe not recognized by many. While there are more cases brought to the second stage than negotiators expected. As illustrated before, dispute settlement cases are not driven by adjudicating body. It is in the hands of WTO members. In the past, it is the major members that have become frequent users of the system. Most recently, more and more developing countries, even smaller economies, come to the playground. My perception is that it is more likely that there will be more cases than less in the future of the WTO dispute settlement. Therefore, my advice to membership is that WTO be better prepared for a booming season of dispute in the days ahead. Perhaps this could not be easily restrained through quantitative restrictions or quotas, or it may not be feasible to define what constitutes an egregious mistake as a benchmark for appeal. The rise of cases could not be anticipated by anyone 25 years ago, and it was nobody's fault. Maybe it is a positive sign that access to international adjudication is no longer a luxury for a small group of members. It represents more egalitarian status before the treaty, which is commendable for membership. Second, contribution of the AB to dispute settlement and international rule of law, a fair judgment. It is challenging for any of us to provide a comprehensive and objective assessment of the institution we work for. However, as the last sitting member of AB before his coming back, I am obliged to say a few words about the work of the Appellate Body as an institution, about my fellow AB members, and about the supporting staff. I will try to establish the observation with facts. Fact 1. Despite harsh criticism comparing with other major international adjudicating bodies, the Appellate Body is unparalleled of its effectiveness and efficiency in history of international adjudication. Its 25 years of operation, the 7-member Appellate Body had resolved 195 disputes, compared to around 160 cases competed by the ICJ with 15 standing judges in 74 years. In terms of efficiency, the AB spent an average of a few months on each case, while other major international adjudicating body usually needs a few years to complete decision. AB also established and maintained a standard and consistent practice of implementing its working procedures, in particular in areas of due process procedure fairness, as well as keeping a good reputation for its adjudication. AB has significantly contributed to the security and predictability of multilateral trading system. Though there are rooms to improve, AB distinguishes itself for its outstanding performance among all international adjudicating bodies. Its accomplishment cannot be ignored by history. No matter how many setbacks it counters today, the establishment of AB was a major achievement in the international rule of law, as well as significant development in human civilization. Fact 2. AB members are a group of fully committed devotees of international rule of law. As required by the DSU, my fellow ABMs are persons of recognized authority with demonstrated expertise in law, international trade, and subject matter of the cover agreement. Generally, AB do not enjoy either lifetime pension of their peers in ICJ or ICC, or the high daily fees comparable to their part-time ICSID peers. I can only think of no better words than willing ox to pay tribute to my fellow colleagues. Fact 3. Appellate Body Secretariat is also the most supportive team I ever worked with. Comprised of only 25 staff in its high time, ABS is substantially smaller, both in absolute and relative terms, than its international peers like Registry of ICJ, which has 116 staff in 2019. Yet the diligence and professionalism have never been compromised under the swelling workload. I understand that WTO members and their constituents have high expectations on AB. AB is inclined to improve once proper guidance is provided. However, given the lean structure of AB, limited supporting staff, the high appeal rate, and increasingly complex matters appealed, it is fair to say that we have delivered what we can deliver and are supposed to deliver. We have undertaken this work, knowing that we have nothing to complain about, and we can only work hard to the end as we promised. I will continue to talk about perseverances, enterprising courage, cooperation of AB in the future, which will inspire the future generations of AB. I believe WTO member will make a proper decision on AB's restoration. As Chinese saying goes, please don't dismantle the bridge after crossing the river. From historical point of view, the judgment of an international adjudicating body and its adjudicators should be at least fair. Now I will skip the underlying reasons and lessons learned. I go direct to the last point, the way forward, suggestion for the future. The multilateral trading system has never been in such a difficult time in history, with two pillars at risk, no DG being sidelined by regional trade blocs for over a decade. It is not multilateral trading system we are familiar with before. Pains of failure of Doha round negotiation did not recede, while new pains of divide on dispute settlement rise. WTO members should reflect over the deep crisis. It is a moment to heal and unite. In my view, mentality of collaboration is essential for WTO reform and the rejuvenation of dispute settlement. Obviously, dispute settlement should be the first item to be fixed. I suggest WTO members put all the issues and their demands on the table simultaneously. The needs of grand bargain, issues old or new, trade and non-trade shall all be put on the table. Then let member draw a blueprint with a vision and make it happen in lump sum or step by step. Next, I will focus on the to-do list of dispute settlement. First, resume the selection process of AB and restore the functioning of WTO dispute settlement, bearing the following understanding in mind. Not adding or diminishing members' rights and obligations shall be put at a central place in dispute settlement. Reinforcing case-by-case dispute settlement mentality, recognizing the importance of dispute settlement's central place in providing security and predictability to multilateral trading system, reassuring WTO dispute settlement serves to preserve the rights and obligations of members and to clarify existing provisions in accordance with customary rules of interpretation of public international law, rather than to make rule, emphasizing restraint style of adjudication at the appellate body, focusing on issues raised and necessary of settling dispute. Refrain from advisory opinions or obiter dicta. Clarifying the issues of 90 days, there should be more communication with participants to seek their views on extension of 90 days. Clarifying Rule 15, an expired AB member to work more than 2 months beyond their term needs to be submitted to DSB. Considering ABM work for one longer fixed term of 7-9 years, 7 to 9 full AB members with wider representative. Considering establishing fixed term and the rotation of the rule of AB secretariat staff. Encouraging like-minded members to join the MPIA and Article 25 of the DSU before the full functioning of AB. Second, improve implementation of dispute settlement. There are many cases that go through the second compliance panel which could last 2 or 5 years or even longer. But implementation are essential issues that members should take care of and try to enhance the quality of compliance by defendant as an urgent matter. Third, strengthen the panel proceeding. Considering establishing a standing pool of panelists, 21 to 30 people, enable 7 to 10 panel to work at the same time, introducing fixed term of 5-6 years and full-time panelists, and random rotation in composing panel by full-time panelists. Clarify optional transparency rules in oral hearing at a panel and appellate proceeding as far as both participants agree, to avoid inevitable breaching of the DSU by panel appellate body in their daily practices. Members may consider simultaneous live stream of oral hearing of AB and 2 substantive meetings at the panel stage. 5. Consider not to allow amicus curiae. 6. Establish a two-tiered World Trade Court, an ideal long-term goal, as this has been designed in the original ITO treaty. To enhance capacity building and narrowing legal gaps among WTO members. The 8th, consider allowing members to litigate in their mother languages. Concluding remark. WTO is standing at a historical path with the next step. Will the rule-based multilateral trading system be strengthened or revitalized, or continue to be sidelined by regionalism or even threatened by unilateralism? Will inclusiveness, equal justice and the treaty, rule of law, and the consistent jurisprudence tradition continue to be valued in the dispute settlement and in implementing the treaty rules? Or frivolous, one-tier, ad hoc commercial arbitration-like approach be the main theme at the dispute settlement? It is high time for members to make decisions. The future of WTO is in every member's hand. I will conclude by sharing with you a famous legend that bears common features in several ancient cultures, including Egypt, Arab, India, and China, the nirvana of Phoenix and its rebirth. With details differing from each other, the central theme of the legend is the singing and the dying of a phoenix in the fire and the rebirth of its another, even glorious life afterwards. I cite this painful, beautiful story with multicultural origin to sow a wish that there will be a glorious revival, a vigorous revival of appellate body in the future. Last but not the least, let me thank WTO members for selecting me and their unabating confidence and support during the past 4 years. Also thank the Secretariat of all divisions for their indispensable logistic support of various types. I thank the academics and practitioners from the legal family I come from. I hope I have represented you well, at least I tried. I also thank my family, my husband, my son, for their lasting tolerance of lack of companion from me, and my mother for her everyday 2 hours prayer for me and her grandson. For every friend and colleagues who helped in this way or that during the past 4 years. What cannot be forgotten is to thank the Graduate Institute, Professor Pauwelyn, and the Global Trade Platform for organizing this event. Before fully discharged from my current duty, there's one matter I can't put aside. That is our talented behind-the-scene professional lawyers who wholeheartedly devoted themselves to the dispute settlement at the second stage. I sincerely call upon each director to treasure them, to encourage them to carry on institutional memory of the second stage and foster their future professional development. They are a valuable asset our institution could ever possess. Our institution should be able to guarantee that anyone who works for its adjudicating body be protected, work with no fear but sense of honor and security, that our institution be strong and long-lasting, and those young who hold their beliefs that independence, impartiality, collaboration, and equality value most all the time. I always say to the team, when each hard decision is made in our case, the measurement is that the last minute of your life, that you don't regret that decision. That is so-called final measurement. It is my belief that everyone who works for the multilateral institution should bear the 164 members' interest in their hearts. That is the final measurement of everything we do here. For the 164, by the 164, and make multilateral trading system benefit the 164. Make sure 164 enjoy equal rights of development and equal justice under the treaty. These are the long-lasting objectives that all of us pursue after. For that purpose, I count on all of you, the promising young generations, to carry on this target and make our world fairer, better, and more prosperous. all farewells are meant for reunion. The Chinese saying for that is, the mountain stands while river flows. My best wishes to all of you. Thank you for your attention.
Thank you so much, Hong. Wonderful. I suggest you stay where you are. I will put a few questions to you. Please relax, drink a bit of water, because it's been a fascinating speech, a lot of information shared. By the way, the bits you skipped, we will fully publish the speech, all of your notes on our website, and I'm sure also the WTO website will do the same. I repeat that the recording of the whole event will be on the Geneva Trade Platform website. There's a couple of questions that came in. Two in particular I will read out to you. The first one came from Victoria Piano, and it's a low ball. It's a pretty straightforward one, but I think you have a big fan already, because Victoria was asking, why did you not use the possibility of a second term? Because you've completed your first term of 4 years. I mean, the answer is obvious, but perhaps you want to elaborate a little bit on that for the benefit of people who are not fully in the system.
Well, I definitely wish, as I said, the WTO member will decide what they'd like to see the appellate body to come back. And if there's a possibility, if members trust me, continue to trust me, I will definitely stay. But that depends on the WTO member. It is all in your hand. As I said, the future is in the hands of all WTO members. It's not me. I'm only a service provider, a professional legal service provider at the international adjudication, which I'm confident I learned a lot in the 4 years. From the first cases, actually, I don't know how to do it, but I was encouraged by my colleague. They say, it's your case, make your decision. And I'm very appreciate that courage. And actually, even from the first case, as I said, in the hearing, I already have many follow-up questions to the participants. And that is also the case I'd like to refer to, which is a extreme style of adjudication. I clearly remember that on certain matters, the participants, one participant requested us to rule over the Article 3 of the SU, which is mostly the general principles of dispute settlement, such as effectiveness of the dispute settlement. And that case is about anti-dumping. It's a dumping measure. And the division, after reviewing the anti-dumping measure, make a decision on the dumping measure, actually declined to rule further on Article 3 of the SU. And that is my first case. I remember very, very well. That is the first case I worked as a division member. So I think the adjudicating style is very different from different members.
Okay.
Thank you for that question. To give this example, I omitted in my lecture.
I have another question here that comes from Mariana Mendes, and she's thanking you for an excellent contribution, and she's wondering, so her question is whether the change of US administration will make it easier for the appellate body to return to normal and elect new members, or do you believe that more substantive reform is needed before this appellate body revival may happen? So I guess that goes to the question of sequencing that you also referred to.
Well, I definitely, my wish that the reshuffling of the US administration will provide a chance that members of the WTO will be able to form consensus on the selection process, on the reform of AB. I believe there are rooms for improvement of AB. As I said, to be more strictly confined with the rules that has been instructed our work, either timing or the style of the drafting of the report, and the more transparency of the operation of the appellate body. The appellate body in the past is very mysterious. It is like it is veiled. Nobody knows how it is operated. In my chairmanship since 2019, I talked with the team. Actually, I would like to push for a reform to increase the transparency and the rotation among the teams, at least the team leader. As I believe if the appellate body member rotate in forming the division, why not the team? I would like to prefer to have an institution transparent and reliable, and everyone play a role inside it, and the role will be properly defined. Not overreach, not underreach, it is proper reach. That is what I believe. The mounting pressures is on us. We have case load pressures, and we need to unite the team together to work, focusing on our delivery of the decision. That is first and foremost. That is why I didn't succeed in pushing too much of the internal reform. That is the pity. Another pity I may have is I didn't have enough dialogue with the WTO members. It is always believed that the ABMs should be isolated. To be very frank, this is a very lonely journey for me. I didn't talk with, friends, colleagues, of course, never on cases. But even I never go to reception, for example. It is purely lonely journey. I stay in my offices and, work from the either offices and home, and not part of any activity except in the discussion in the conference room of AB. That is the only chance I talk. And except for that, we even don't talk with lawyers in the corridor. For me, I think somehow we should foster a more open and transparent method of working or style of working. That is something I prefer, but didn't happen this time. I'm not sure there will be another time for me, but I encourage the future generations, if they come back, they will have more chances for more renovations within the system.
I have a few more questions, if you don't mind. So I have one here from Yannick Trudel, who asks you, with the NPIA in effect, do you see this mechanism becoming the foundation of a new long-term replacement solution? And also, do you think the NPIA increases the risk or reduces the risk of fragmentation of WTO law?
Well, I definitely don't hope it is the long-term replacement for the second stage education. I think it is named as interim solution. I hope it is interim. It is just want to, I guess it is designed to fill in the gap between the coming back, between the recession and the coming back of AB. It's not meant for a long term. That is why it is designed that the panel report will be suspended under Article 12.12, and at that point there will be an arbitration. So technically they never reached the appeal stage. It's still in the panel stage. That for me, gave a different legal nature of that mechanism that distinguishes it from the appellate body stage. And could the MPIA increase or reduce, increase coherence or reduce the fragmentation of the dispute settlement? I hope it will increase. That is the purpose of establishing this mechanism by this over 20 members. I hope it work well. I hope it will work for those like-minded who would like to carry on the idea of increasing coherence of international adjudication. And I wish them good luck.
I have a few more questions, and sorry, but but there's a lot of interest, it seems. So some people are very keen on hearing your thoughts on non-trade issues, as they are often referred to. So Grisel Meneses is asking about your views on the role of the WTO in the global efforts to solve the climate crisis. And another person is asking, this is Islam Atiyah, what is your general assessment on the way that the AP has dealt with non-WTO regimes like environment, human rights issues within trade disputes? So those two questions really try to get at your views on non-trade issues before the appellate body or before the WTO more generally.
In my view, even in the time of the early days of AB, it is not possible to really isolate the trade and non-trade issues. For example, the shrimp, turtle, and a few other cases that already involve the idea of promoting sustainable development and protection of environment. And currently, to me, when I communicate with others, I will say the WTO is in crisis. But the climate change is even big crisis and challenge for mankind in totality. We don't know whether the climate will be even devastating, that will be more warmer or not. The sea level rising is a threat for many. So if we couldn't unite and put our strength together to fight against climate change, the crisis is even bigger. That is for the existence of this mankind, for many population. So the world is very divided. But I hope in many areas we are divided. So how to connect people together, unite people, and put together all the strength together to fight against the crisis, the pandemic, the climate change, these existing threats to human beings are first and foremost priorities of all of us. So the trade rules in world perspective can make contribution to the fighting against climate change. I think it's a priority that members should consider. For me, it is always everything is connected. And we are doing the things from different angles to achieve the same objective. So for me, I haven't been put a lot of energy on study of the climate change. I know there are some rules, but I'm not so sure what has been developed at the WTO currently. I'm too isolated in the past 4 years, but I'm an expert on investment. For me, I think trade has fundamentally been changed by the GVC, the global supply chain. 70% of all the trade is among multinational companies, the intra-company trade. So the investment is a key element, a key driving force for trade. That phenomenon alone makes the trade rules and investment rules connecting closely with each other. So what shall we do? And the investment rules, as I said in other forum, is even fragmented than trade rules, over 4,000 BITs. Like most complicated spaghetti rules. How could that benefit investors? So I think there are many things we can do. But now, FTAs also, there are hundreds of them, and the number are increasing. So how could these trade rules become a leveling field? WTO is definitely a platform, but how to utilize this platform to make it viable? As I said, 10 years ago when I worked here, I feel the mortality of people talking and working with each other, try to seize that window opportunity, try to deliver at Bali and Nairobi. We did something at the time. I'd like to see that momentum to come back again.
Thank you. A couple more and then we will have to end it. But I have a question here from UN1 who is asking whether, in your view, the proliferation of the regional trade agreements like the RCEP and the CPTPP will diminish the legal regime of the WTO.
Well, I don't think that RTFTA, whatever they are, can diminish the WTO rules. I think the fundamental function of the WTO as the leveling field is still vital for everyone. Take the Brexit, for example. The British government and the European Union, while they threaten with each other, they have to say we still have WTO rules. But that is only just an example, and I think all these RTFTs still build upon this fundamental leveling rules. But how to make WTO a really viable position or forum to formulate new trade rules, or trade-related rules, or non-trade rules that is compatible for the purposes of the WTO is really a challenge issue for the negotiators. I hope I can make contributions from tomorrow on in that regard, because I'll be liberated from tomorrow on.
Okay, wonderful. Thank you so much, Professor Zhao. This was very stimulating. It was a pleasure to hear your farewell remarks. Thank you for being with us. Thank you for the tech support we've received from the Geneva Trade Platform. And unless you have any final remarks, I would close the session. Perhaps you have some final remarks?
I actually didn't prepare much fair remarks. I skipped most of the parts. I hope you will organize another seminar as a follow-up, because I didn't touch the reasons behind and the lessons learned. That is important part. And for jurisprudence, for precedent, for different issues, I think I skipped most of them. The overreach individual cases, I also skipped. I hope I encourage the dialogue among trade communities, among WTO members, among judicators and negotiators. I think we should have more dialogue. To me, the world are much more divided than before, than we can imagine. So how to unite the people, how to put the energies together, not let people be in a rivalry, but in the collaboration with each other, is a challenge for us all. And for me, I think the working 4 years here in Geneva make me better understand the area I am in. And I also try to understand what is the identity of the home country I come from. There are many things to study. So try to identify yourself in this multicultural, diversified environment. While globalization is not the same as before, someone said it's under the new normal, it is still continuing. So I guess the clash of mind, of the people, of the culture will continue. So communication and dialogue is the only way that we understand each other. As I said in my understanding of the crisis of AB, mostly it's the clashes of mind, the clashes of ideas of what is the ideal judication. But this is realized only lately. While the views of this complaints about AB, I think, is a bit coming up, and then lately I realized it is the approach, a consistent approach, or it is a case-by-case approach. Of course, it should be case-by-case, but bearing to mind that the decision should better be consistent as well. So it should be both. So how can we achieve that? Is that difficult? I believe as far as we have the political will, we'll be able to resolve everything. Human beings do have the wisdom to overcome all the difficulties. As far as you change the mentality that you like to sit down to talk, to collaborate, to put the energies and the strength together, rather than to have internal fight with each other. If any final words, that is my final words.